I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole nine yards or nothing.
Welcome to Legal Straight Talk. I'm Brett Harrison, an attorney from the Harrison Law Group. And tonight we have a special guest with us. I'm going to try to pronounce her name phonetically. Betty Tufariello. Is that good?
Absolutely perfect.
Okay. And the area that we're talking about is as difficult as your name to pronounce, and it's called intellectual property.
That's right.
Now, to me, normally I would say it's Greek to me, but not to you for numerous reasons. One, you speak Greek,
I am
you speak
Greek.
French, you speak Italian,
That's right.
you speak Spanish,
Yep.
and obviously English.
Obviously.
Okay. However, you are an intellectual property lawyer, and that's a confusing concept to me because it deals with trademarks, it deals with privacy laws, it deals with copyright, it deals with patents, it deals with so many things. And you know where this came to light? More people are aware of it, quite honestly, because of Shark Tank.
That's correct.
Non-lawyers, as well as myself, because I watch Shark Tank, and I see, oh boy, here we go. They always mention trademark this, did you patent that? Well, this is pending, that's pending too. Well, you got to protect your rights because someone's going to take what you just trademarked or potentially trademarked and take it to China, produce it, and utilize intellectual property.
Right.
Okay, let's simplify this.
Sure.
Educate me, educate everybody else, because honestly, it's such a confusing area. Break down intellectual property. What are the areas that it falls in? And do me a favor. Give me, in plain English, not legalese, not Greek, not Spanish, not whatever language you can speak. Plain English, break down to me the areas in one sentence in each thing about it. And I know that's kind of hard to do, but give me a breakdown.
Sure. Intellectual property law basically comprises 5 different areas of law: patents, trademarks, copyrights, trade secrets, and privacy and publicity rights. Although some intellectual property lawyers, because those rights tend to be state law rights, don't lump them in with intellectual property. But at least in my office, we do, because what we try to do is we try to protect companies and people, not necessarily just intellectual property, because intellectual property can be used effectively both as an offensive tool, in the sense that you're building value in your company and you prepare yourself for a possible merger or an acquisition, like in the case of Shark Tank, or defensively to protect what you have so that you can grow it and you can become more competitive.
So the whole concept of intellectual property is to protect your asset. And that asset, which equates to money and equates to potential future sales, the valuation of your company itself, comes down to how can we first the question, is it protectable? Is it an asset that, and I guess, is that how you start? Do you look, when somebody comes and I come to you and I say, listen, I want to protect my asset. I want, and you're going to say to me, what do you do? For example, there's recent litigation, or you and I were discussing off camera. Let's make it juicy for people so that people can understand.
Sure.
Christian Louboutin shoes.
Yes.
For women, these shoes cost thousands.
Well, to be exact, $750.
That's for the base one. That's for the base one.
That's
but
correct.
But it's interesting. The Christian Louboutin shoe, I mean, they are known. It's an art. It's almost like an art, and a very specific art, which is, I guess, what they were trying to say, that we should be able to trademark or protect our design. And it has to be something that would be, I would imagine, something so specific to that design. And in this case, it was what?
The color red on the sole, the underlying sole, the outer sole, so that when you just picture the shoe as you flip it over, that outer sole is red. Every Christian Louboutin shoe that is out there, whether it is a pump or a sandal or a slipper or a pair of sneakers.
Or has that red on the outside?
No,
right?
it's the entire sole.
It's just the whole sole or just the outline
The
of it?
entire sole.
But now, that's a little crazy. I got to be honest with you. We're going to court, and we're fighting over to say, you know what, Eddie, you cannot put a red sole
That is
Now-
absolutely correct. You cannot. And as a matter of fact, I represented a client who unfortunately I can't reveal
Well,
because
hold
of
on. Let's go back to
confidentiality
this.
issues.
So you're saying now that if somebody does, if they did win, and I will get to whether they won or not,
Mm-hmm.
they're trying to protect that. They're saying that is our signature image.
That is correct. In other words, what Christian Louboutin is saying is, look, trademark office, or look, court, whatever court they
And now,
are
is
in.
that usually a federal? Shouldn't that be a federal court?
Well, trademark law is both in the federal and the state, but usually when a trademark is registered with the federal government under 15 USC, which is the title for trademarks, when you have an actual registration of a trademark, you would rather be in federal court than in state court.
Well, I'm sure for numerous reasons, because I'm sure it'll get resolved quicker.
That's right.
There's less nonsense, there's less stalling.
That is correct.
However, is there what we call in the industry forum shopping? In other words, if it's more advantageous to be in a Virginia state court as opposed to, let's say, the federal court, it's more favorable, let's say, this ruling or that state. Can you do forum shopping?
Definitely, although it's frowned upon, as you know, by most courts.
But you know what? Better to beg for forgiveness than ask for permission to forum shop.
Yes, absolutely.
Let the other
absolutely.
side make a motion.
Absolutely. But you find that most trademark cases are handled either in the Ninth Circuit, which is California, because we have a lot of industry out in California, fashion and whatnot, and New York, the Second Circuit. So we see a lot of trademark cases coming out.
Now, are they
out of
similar
these.
in their rulings?
You know, the standard is likelihood of confusion. Is the consumer likely to be confused when they see the
And is it
defendant's
material also, I would imagine? Is it material to my product?
Yes.
It's gotta be- it can't just be a
There are a
small
number of
thing.
factors. When a court decides whether there's trademark infringement, the standard is confusion. And in order to decide whether it is confusion, they have a whole series of factors. In New York, they're called the Polaroid Factors, out of a case called Polaroid versus Polaroid, which came out in the 60s. And that particular case, which made it all the way up to the Court of Appeals for the Second Circuit, actually laid out 8 factors that the court could evaluate. They're not exclusive, and they're not what we call cumulative. Any one factor can actually win the case. But there are 8 factors that the court recommends.
Is
that
it your goal then to show that it falls into each of those 8 categories?
Well, yeah, when I'm the plaintiff, I usually try to say, well, look, Judge, I want factor 1, and I want factor 2, and I want factor 3, and I want 5 out of the 8, so you need to rule in my favor.
Now, as we're talking, what comes to my mind, and I could be way off, so I need you to correct me, but I'm thinking, if I'm on the other side of whatever it be, whether it's Christian Louboutin or what have you, am I going to say now, it's if you grant them a patent or a trademark as to the shoe or whatever else it may be, you are essentially creating a monopoly and precluding fair competition?
The question of whether you are granting a monopoly and preventing fair competition comes up a lot in the context of patents and copyrights. In the case of trademarks, we're not so much concerned about monopoly as much as we are concerned about confusing the consumer and placing the consumer in a position where, as a result of that confusion, they're making a commercial decision that hurts the consumer. That's why the standard for trademark infringement is the consumer likely to be confused? Now, if in fact the consumer is confused by the defendant's trademark, whatever the defendant adopted, which the plaintiff can't stand and goes after, if as a result of that the defendant is in fact confusing the consumer, then in essence the plaintiff has a monopoly. But why shouldn't he? If the plaintiff has adopted a mark, has marketed the mark, has expended hundreds of thousands of dollars advertising and promoting the mark so that he can sell or she can sell her goods.
But you know what?
And the defendant, let me
that's
just finish
the-
the
okay.
thought. Let me finish the thought. And the defendant adopts a trademark which will capitalize on the goodwill associated with plaintiff's mark.
That I understand that.
Okay? Why should the defendant get away
But
with
okay,
it?
but now let's play the opposite game. And like I said, this isn't my milieu of what I can do, but I've never done this. But if I'm thinking on the other side, if I'm a heavy-handed or heavy-moneyed plaintiff, okay, in this case, behind my corporation is a lot of money, shareholders, I am going to promote it on commercials, in paper, on internet, in a certain way to make sure that whether it's the red lining around the whole thing, I'm going to always make sure that that's a key thing.
Sure, and you should.
And you know, but by doing that, I'm intentionally setting myself up to trademark, patent, whatever you want to call it, trademark that thing. So that concept to prevent others. I might not even think that's not the true value. The true value is the quality and the artistic design of the shoe, which is really what I think it is, more than the red.
Actually, it's not the artistic design of the shoe, because if it was the artistic design of the shoe, Christian Louboutin has enough lawyers sitting in the back room that they would have strongly recommended he file a design patent.
Okay, he may well have done that too.
He did not. That I can assure you, he did not.
Or is it hard to design something when it's a shoe because you're dealing with a foot?
No, because there are a lot of design patents with relation to shoes in general. There are a lot of design patents, and many have been filed even here on Long Island by many good firms. But the reality here is the confusion to the consumer. If I'm the plaintiff and I'm expending that kind of money, I'm doing it on purpose.
But you also know it's a Christian Louboutin shoe because it says Christian Louboutin, number one.
Yeah, but how would you know it? Christian Louboutin, the name itself, could not be protected until it had acquired secondary meaning. In fact, the red sole...
What does that mean in English?
I will explain to you. The red sole itself could also not be protected.
So the red sole has to come before the Louboutin name?
Not necessarily. They probably came out at the same time, around the same time.
No, in order to trademark or protect the Louboutin name, you have to associate it...
with the red sole, and vice versa.
Right, equally, but it's the chicken or the egg.
In the case of the trade...
Well, first came Christian Louboutin because then came the shoe.
Look, I need to get back to because and I understand the fascination and your questions, but the reality is this. What is a trademark at its most basic concept?
Give me the basic concept.
At its most basic concept, a trademark is nothing more than a shorthand manner of communicating to the consumer the source of the goods. Okay? So, for example, the swoosh on Nike. No matter where you see that swoosh.
I know it's
a swoosh and it's Nike. And there is no doubt in your mind that particular product originates with Nike. And if you're a big Nike aficionado and you love Nike products because they perform well, because they last well, because they don't fall apart in the washing machine, okay, or they don't smell after you've had a real hard time at the gym, you're going to make a consistent decision to purchase Nike products. And when you see that swoosh on the shoe or on the shirt, you know that's a Nike product. Now comes along the defendant, right, and says, I'm going to take this little swoosh and I'm going to put little wings on it, but it still looks like a swoosh, right?
But there the intention is to copy, and I get that. Now there is intentional confusion to the reasonable consumer. I get that.
That's what trademark's all about.
Perfect.
That is what trademark is all about. That's exactly what it is.
Now I'm ready to work for you.
Because once you understand that, and that's one of the reasons why people say, oh, you're preventing me, you have a monopoly. Heck yeah.
Because that's your first argument.
That
has to be.
It has to be, exactly. So it's
confusion. You can't prevent me from going into the market.
You can do it, but don't do it at my expense. Right. And don't do it at the expense of my consumer. And what most people need to understand when they're dealing with trademarks is simply that trademark law was designed to protect the consumer from confusion, so that when they go out and they lay their hard-earned money,
there's an expectation.
There is an expectation that what they're buying is exactly what they think they're buying, and not some counterfeit product from China. Although even the good products come from China now, so that's not the issue.
A lot of the pieces are made in China.
Absolutely. But the point is that there's a certain level of performance and quality that I, as a consumer, have come to expect from the product. And therefore, when I put my money down, I'm expecting to get that particular company's item. So going back to the chicken or the egg, right? Who came first, Christian Louboutin or the red sole? Well, it kind of came together. Because now women who want to be fashionable and sexy and at the same time wear comfortable shoes, because allegedly they're very comfortable shoes. They buy a Louboutin pump for $750 or $1,000 or $1,500, and they buy it simply because they recognize the red
It's
sole.
a status.
Status
As one
symbol
might
as well.
buy, as
That's
one
the
might buy
reason.
a man may buy a Rolex watch,
Or a
Bilingual
BMW or a Mercedes, whatever it is.
Exactly.
Exactly. So
They're trying
that's
to
what
let the world know
trademarks.
we're quality, I'm buying quality, I'm wearing quality.
Now, patents and copyrights are a whole different bowl of wax. Totally different. For example, patents. First of all, let's get this clear. Patents do not protect ideas or concepts. Neither do copyrights, as a matter of fact.
Okay, what do they protect?
Patents, there are basically 4 categories of things that a patent will protect.
Okay.
Machines, and a machine is defined the way it was defined in physics class when we were seniors in high school.
Well, that was
Okay?
not only 2 years ago for me.
All right, so it's machines, it's mechanical devices, it's
Okay.
compositions of matter, and it's processes. Okay? If
Like,
you're-
for example, patenting a formula in math.
Actually, that's the one thing you can't do.
I
Mathematical algorithms
they-
are in fact excluded, as the same thing, things occurring naturally in nature.
'Cause I thought, believe me, now that you brought up college or high school, one of my college roommates, according to him, he patented a formula for the area of an ellipse.
Yeah, no.
That's what I said.
No.
Okay.
No. On the other hand,
So, Greg, if you're listening,
if the area of the ellipse and the use of the area of the ellipse was
The formula.
programmed into a computer, and the computer used that information to calculate the curing time of a tire,
Then he
and
could.
as a result of it, released the mold in which the tire was poured, now it's patentable.
okay.
So-
You lost me after.
The bottom
If.
line is, if mathematical algorithms are part of a machine or a process that are,
If they're an intricate part of that process.
then they can be patentable.
Okay, because you can't separate the algorithm from the machine.
That is correct.
Gotcha.
That is correct.
But now
So-
this was an area that was interesting. We again talking off. I want to make this kind of interesting. You were talking to me about. We were talking about photos.
Yes, photographs.
So sometimes a
before we
lot of
started.
people on their website or other things, you'll use a photo and say, well, it's out there in the public. I should be able to use it. But now you use it for financial gain or to identify with your brand, your name. Now
Oh,
all
it
of a
happens a
sudden,
lot.
you get a letter from who's ever protecting Getty Images or whatever
Mm-hmm.
images, but they seem to be, a popular name, the Getty Image. You get a letter. And what would that letter typically say?
Typically, it would say, we are the owners of the copyright associated with that picture. We have spent a lot of money protecting that picture. We have not authorized anyone to use that picture. It has recently come to our attention that you are using our picture without our authorization. We just wanted to let you know that you are in fact infringing on our copyright.
And we could sue you for how much?
A lot.
Okay.
Okay.
However, unless you get what? You purchase the permission to use that picture on your website for whatever. It could be $1, it could be $40.
That is correct.
Because I think, what do they have it now on the internet? Stock images.
right. That's
you can
right.
purchase stock images. Some are $1, some are $10. But what that does is allows you to use that image, long as it's for, I would imagine, whatever purpose. It's got to be
It
legal
has
purposes.
a very, very limited purpose, extremely limited
Which
purpose.
is?
Well, basically what you're doing is you're buying the picture together with a license,
Okay.
with a license to use the photograph for a particular reason. And usually they tell you what that reason is on the terms and conditions when you click, or alternatively they will ask you, why are you purchasing the photograph? And if you they give you all the options, and then you click off on one, and now you're purchasing it only for that particular purpose. You see, I went to Hofstra Law, and we had a fantastic professor who taught copyright,
it?
Leon Friedman.
Okay. I went to Hofstra Law too, but
Awesome!
I did not have Leon, but I do remember him.
Okay, well, Leon is a fantastic copyright, because
Oh,
remember,
okay.
it was Eric Friedman, too, who used to teach.
Totally
still
different
does.
personalities, too.
Right, exactly, civil
Think he took-
procedure.
yes,
So Leon Friedman used to say, copyrights are like a handful of pasta. The entire copyright law is the individual strands of the pasta. And
Okay.
you can actually separate one strand at a time and give a different right to every person who comes to you to use that copyright. So you can have a right to use the product or the picture or whatever art we're talking about for a particular purpose, or the right to reproduce and distribute, or the right to perform. Each one of those rights
Is a separate copyright.
no, the copyright is one.
There's
But
one.
that copyright can be divisible out
Ah.
to individual things, individual rights that people can do with them. So the person who goes to these websites and purchases a picture or purchases stickers or whatever
Right.
it is, they're purchasing it for a one-time use or a single use on a website. They can't reproduce it. They can't deface it. They can't sell it in the strict sense. Because if you have a website and you have a picture on the website, chances are you're trying to attract people to your website to do business. Either you're selling your services or you're providing your goods. But your goods themselves have nothing to do with the actual
The
picture
goods
that
are
you're
you
using,
as opposed to
the picture.
Right.
So we're separating it out. So in that case, they tell you, you need to get a license from us. And you can use it only for that purpose. And if your website goes down and you build a new website, you can't put the same picture. You have to buy the picture again.
Oh, really?
Or alternatively, it depends. These packages are always kind of moved around.
I can't imagine most people read the fine print.
No, they don't. But most people also don't get into a lot of trouble because when they purchase or build their website, let's stick to that particular
Right.
hypothetical, right? When they build their website, they build it for a very narrow use. And therefore, they don't get into trouble because they don't go beyond that use. So those particular licenses are very different. Now, let's just kind of separate a little bit. We were talking about patents. We were talking about machines, mechanical devices, compositions of matter, and we were talking about procedures. Copyrights, on the other hand, protect something totally different.
Okay.
Copyrights protect even a modicum of artistic merit, of the thing that gets reduced to a tangible medium.
Whether it be a CD of a song of
Could
an
be
artist.
anything. Could be on the computer, it could be on a CD, it could be on a canvas, it could be a three-dimensional sculpture, it could be your blueprints that you put together for your house. That's all protected under copyright. Copyright is the artistic merit. In other words, that thing that you see that you recognize when you first see it. It's like, beauty's in the eye of the beholder, or another cliche phrase, pornography, you know it when you see it.
Right.
Kind of the same thing. When we're talking about copyrights, we're talking about that artistic value, that artistic something that would cause someone to take the thing that was created and put it up on a wall, or stick it at the corner of a dining room table, or in the middle of a dining room table so that it looks pretty, quote unquote. That's what copyright protects. It protects that artistic merit. No sweat of the brow. Just because you spent hours and hours and hours creating it and hundreds of thousands of dollars to make
Right.
it doesn't give it copyright.
Okay.
Famous case, Feist, 1991, 1992, Sandra Day O'Connor. She came back. The case had to do with the yellow books out in Oregon. Okay? Company had 4 of them. Some other company decides to merge the 4 and make one. Right? Yellow pages. The people with the 4 books sued the people with the 1 book and said, you're infringing on my copyright. They lost because the work of the brow, because what's in the yellow pages, right? Yellow pages and lists and lists and lists of
Right.
businesses. No artistic merit, Sandra Day O'Connor said.
Oh, okay.
Therefore, no protection under
So
copyright.
artistic merit could be summed up as that. What's the phrase? The je ne sais quoi.
That's right.
Okay.
That phrase came 3 times into my head, and I kind of shied away, but I'm glad
I
you
can't
brought it
spell
up.
it, but you speak French, so you could probably say it better
That's
than me.
exactly what it is. It's that little something that
It's that something
that touch,
something
that
that gives it.
touch, that if you're Italian or Greek, you know what I'm talking about. Or even Jewish, that thing that I can't put my
that-
finger on, but it's there, and that's what copyright protects. That's what it's all about. So, so patents are, we said, machines, mechanical devices. Trademarks is the source identifier.
But who makes the decision whether you get I mean, I almost feel like you send in your application for patent,
Mm-hmm.
copyright. Who makes the decision? You get this feeling it's this old person or an experienced person sitting behind a glass wall.
You have no idea how correct you are.
It's almost like you feel like you're at the U.S. Mint with guns at your head to make sure nobody else can steal it. So what is it? I mean, that's my perception.
Let me tell you, your perception is not too far from reality, because particularly in the patent office, the way these poor examiners work, it's not even fun.
Feel like they have
Patents all the way, patent applications all the way to the ceiling. You're not kidding. So who makes the decision? Basically, the people that are sitting behind the desk. They look at the applications, they evaluate them, and they make a decision, and that's what you rely on.
And how long does it generally take?
It depends.
They have to research and
Patents takes a long time. Copyrights, not so long.
and then you get
Trademarks,
these long
not so-
numbers.
Serial numbers, they're called.
There you go. You get these long serial numbers.
That
and
is
then,
absolutely correct.
And it could take a while. But then you always hear it's patent pending, whatever. That's kind of means we don't have it yet, but we did put it in. Doesn't mean we're necessarily going to get it.
But it has so much beautiful value.
Does it? What is the value?
Well, the value of a patent pending is exactly that. You're giving notice to the world that this particular invention, this particular thing has
Is
a
now
patent.
first in?
First in, there's a patent application pending, and watch out, world, because we're coming down, and we're going to get a patent. And if we catch you copying, you're going to be in deep trouble.
Well, Betty, unfortunately our show is ending, but we're going to have you back probably for round 2, and we're going to get into some other issues and have some fun with it.
Awesome.
I appreciate you coming down to our show, and you can catch us on Cablevision, and you can also catch us on our website, hlgny.com. And once again, thank you, Cablevision. Thank you again.
My pleasure. Thank you. Thanks for having me.
Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.